Hello, everyone. If you thought jury selection day one was going to be smooth sailing and everything was going to be nice and calm, you haven't met Lauren Daybell, as she likes to be called now. Take a listen to this. We're going to get all into it, but just listen to one part of today. Take a listen to this.
We didn't find these specific aggravators. Being a dangerous offense and these specific aggravators.
Can I finish what I said, what I was saying? Right? I didn't interrupt you. Can I finish? Okay.
All right. That's just a preview of what we're going to get into today for day one jury selection recap. And I'm going to bring you the details from inside the courtroom every day right here in Phoenix. So hit subscribe and thank you for supporting the channel. But before we even got into those jury questionnaires in Judge Boresky's courtroom, before we even got into Judge Boresky's courtroom, Lori Vallow made a surprise move. While the media focused on her latest motions, I was sitting right here going over those. Lori was secretly sitting in a closed door hearing with a different judge, trying to get Judge Boresky kicked off the case. And no media had been invited. They had no idea. None of us had any idea it happened until after the 11-minute hearing had concluded. And if you've been following the Lori Vallow Daybell saga, you will remember that last week she demanded Judge Justin Boresky to step down, claiming he's biased against her. You could practically hear her foot stomp. She was so upset that he never grants her motions, and the judge explained he would if he had any legal merit. He refused to recuse himself, so of course, what did Lori do? She filed yet another motion. So let's break it all down and see if this judge takes her side. So like I mentioned, after Judge Boresky denied Lori's request for recusal, she filed a motion on May 20th that stated, quote, the defendant, Lori N. Daybell, files with this motion and her affidavit as shown that the Honorable Judge Boresky has a personal bias or prejudice against her. As a result, the defendant cannot receive a fair or impartial hearing or trial before the court, end quote. This was just one of several complaints that Lori has, which again was heard today by Judge Jennifer Green. Judge Green summarized Lori's motion by saying that she was requesting that the court remove Boresky for cause under Rule 10.1. Her reasons include denying various motions, facial expressions, the judge's vibe, the rack belt, violating her right to a speedy trial, religious persecution, and personal bias. And Lori was then given the opportunity to address the court. First, in regard to this motion, she stated by saying that she believes Boresky displayed biases and prejudice against her during the last trial and throughout the entire time he's been a judge on her cases. And since he refused to recuse himself the first time, again, Lori decided, again, to put it all in writing. And the first complaint she brought up was a comment that Judge Boresky allegedly made during her last trial. Lori explained that while she was cross-examining one of the witnesses, Boresky told her that she was comparing herself to a biblical prophet. She said that she didn't notice that until after the trial because she was so focused on the questioning, but believes the comment was inappropriate in front of the jury. She also mentioned again that it appears as though Judge Boresky just denies all of her motions and that he told her that it's because they do not have any legal merit. Lori believes that he even denied all of the motions brought up by her previous defense teams. But if you recall, Boresky granted one of her motions that very same day that she was originally complaining. But nonetheless, I think we need to hear it from Lori herself. Take a listen to this.
Made an oral motion with Judge Boresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me. And that obviously you've read it, so you've seen all the different things that there was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else?
So prosecutor Trina Kay responded to this allegation by saying that the majority of the prior defense motions were requesting to preclude the media. She said that Boreski applied the appropriate law in response to these motions and placed limitations on the media to mitigate any concerns while still granting them access. And other than that, Lori's other motions had no legal basis and were appropriately ruled on. And if they did have a legal basis and he still ruled against them, that would be one thing, but simply denying motions without legal merit does not constitute a bias. So after this comment, Lori argued further, saying each time one of her motions had been denied, Boreski hasn't given her any finding, a fact, or conclusion of law. And if this feels repetitive, like exhaustingly repetitive, it's because it is. Like she just, it's like a merry-go-round. She doesn't stop. So let's listen to a few of her specific complaints that pertain to this next trial coming up. So take a listen to this.
Conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today.
So, by the way, about that missing discovery, we learned today through a motion that there were 2 pages of Tammy Lapchick's report missing, that the state didn't have either. They went and they found it, and they did hand it over. So this is not discovery that the state had and that they didn't hand over to Lori. This is discovery. This is evidence that they just found. And that was sent over today. We talked about that this morning when I went live here this morning before heading to jury selection. So, of course, since I talked about repetitive Lori, don't worry. Of course, she had to bring up the rack belt, or as we know, the stun belt, because she just cannot accept that she has to wear one during the next trial. She also still can't seem to accept that she's a convicted serial killer. So heaven forbid she has to wear a stun belt. And she still believes that it was the recommendation that the sheriff's office was for her to not wear one, even though we read the sheriff's office recommendation together here, and they said that she does need to wear one. So let's listen to her argue this once again.
I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended.
We have gone over this before. We have gone over this and over this and over this. Judge Boreski went over this matter with Lori and clarified that the sheriff's office didn't actually recommend that she be without one and that they were just giving a general list of options. The sheriff's office came and said they do recommend that she has one. They've explained that they do not have a guard that is armed that they can have every day in court. But Lori didn't like his answer, so she believes that he is being biased towards her. And the next thing Lori discussed was the juror who she believes learned about her criminal history before sentencing. Lori said that the media sent Boreski a clip of the juror saying that he learned about her prior convictions before deliberations. But as we know, that's not true. She also said, in other words, nowhere did Carl ever say that he learned about her prior convictions before deliberations. He said some things that made people concerned he knew about them, but he never said that. She also said, but he never said that. But Lori also said that in a hearing, Boreski told her that the juror took back what he said. But that's not true either. There was no takey-backy from Carl. He didn't take back anything he said about not knowing. Before he made this statement, he said that he did not know about her her other convictions. After he made this statement in question, he came on our channel, Hidden True Crime. During our interview with him, he clarified what he meant in that comment. But Lori thinks that that situation was grounds for a new trial. She also said that Boreski refused to call the juror in to swear under oath that he did not know her previous convictions prior to deliberations. But in conclusion, Lori just doesn't believe that she will be able to have a fair trial unless she has appointed a new judge who doesn't know anything about her or her case. So let's listen to all of this.
The thing that I asked for has been denied. I feel like he does have a personal bias against me. And all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and
So up next, Judge Green had several things to say in response to Lori's flurry of complaints. She said that the fact that Lori disagrees with Judge Boreski's rulings doesn't constitute a legal basis to grant her a new judge. Judge Green said that just because the rulings didn't go Lori's way doesn't mean that Boreski can't be fair and impartial. In regard to Lori's other complaints, Judge Green said that she can take those up on an appeal. There are other legal remedies for her arguments that do not require her getting a brand new judge. Basically, once again, motion denied. Again, Groundhog's Day. Again, as you can imagine, Lori was not happy that even another judge wasn't going to agree with her, which was demonstrated in her final comment that we can listen to here.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you. We are adjourned.
Moving on. So what a morning, right? Motions, secret hearing, a new judge. But now moving on to this afternoon, jury selection officially began in Judge Boreski's courtroom. And I was there again, and most of the afternoon was spent going over jury questionnaires. They are numbered A2 through A302, meaning, yes, that many jurors. And this was interesting because if you crunch the numbers, which we did for you, so you don't have to, you're welcome. This is where we really get a sense of just how many people here know about Lori Vallow Daybell. That's always a question we have, right? How many people truly know about her or don't know about her? How many people are in the know about this case that has now been going on for 6 years? So here are our findings. And for comparison's sake, let's rewind first to her last Arizona trial. That was when she was convicted in the murder of her then husband, Charles Vallow. And over the course of 2 days of jury selection back then, they screened 211 jurors. So 90 of them already had prior knowledge of Lori and the case. And that averaged to, you ready for this? 42.65%. And don't worry, guys, I've let you know my math skills aren't solid. So I gave this job to somebody else who has great math skills. This is what they came up with. The average of 42% last trial earlier this year knew about Lori Vallow Daybell. Okay, so compare this to today. I believe that the final count, here we go, 294 jurors were screened. So more, 294 just today were screened. 126 of them had already had prior knowledge of Lori and this case. And so that averaged out to 42.85%. So essentially exactly the same amount. Out of those 294, 66 of them are proceeding to further questioning tomorrow, because when it comes to picking these jurors, it seems like the number one thing they want to find is someone that has never heard of Lori Daybell or Lori Vallow. And that's why I use both of her names too. I know people get upset that sometimes I still call her Lori Vallow, but some people know her through that name. But she is Lauren Daybell, married to Chad Daybell now. So 66 of them are proceeding to further questioning tomorrow. And I just want to say that finding out that the percentage is exactly the same as it was just a couple of months ago makes me realize that people are probably telling the truth. And so, again, it's interesting. So 66 of them are proceeding to further questioning tomorrow. The other 102 people were released for various reasons. We will go through all of those numbers individually at the end of this video. We took excellent notes. I am that certain of our note taking that I can say we took excellent notes. And so for those of you who would like the specific breakdown on what the ruling was on each individual juror and the reasoning behind each one, stick with us until the end. Again, this is not, there is no camera in the courtroom during this time to protect potential jurors. So we have the numbers for you. But again, before we get into that, I know not everyone likes all these lists. So we're going to jump ahead to what happened after we concluded juror questionnaires. After that moment, Judge Boreski said that he would be going through a number of motions and outstanding items before voir dire tomorrow. And that was when Lori piped in and said that she had 3 things that she wanted to discuss, but she didn't know if Judge Boreski wanted to at that moment. She was like, when do you want to do this, Judge Boreski, who is now her judge, whether she likes it or not? And I also want to throw this out too. Until this point, think about this. Let me set the stage here too. Lori has now tried to get Judge Boreski kicked off of this case multiple times, to his face, in writing. She has accused him of multiple things, including what he looks like, his face, how he's not fair. And I would say, I've always said that Judge Boreski does a really great job gray rocking, meaning just showing no emotion, a poker face, being calm. I would say he absolutely was this way today through jury selection. He was even. You would never know that Lori had just been in a hearing ripping on him. You would never think that he knew that walking into court. Lori was in her orange jumpsuit today. She was handcuffed at her wrists. She had shackles on her ankles. She likes to shake her feet a lot. I was really, really close to her. I said on the first row, I was as close as you could possibly be to Lori. It's a smaller courtroom in Judge Boreski's courtroom. I was very close to her. I could see her. And again, the judge was even, calm. So she says, look, when can I do this? And Judge Boreski continues to be calm and says, you know what? Why don't we do it right now? Why don't you go ahead? And that was when everything changed. It was a pretty explosive hearing with Lori arguing with Judge Boreski about the need to include a quote unquote aggravation phase during this 3rd trial of hers. And so what she's referring to is when aggravating factors or things that increase the severity of the crime are presented before the sentencing phase. So in capital or death penalty cases, which this is not a capital or a death penalty case, the judge made that very clear in this hearing. And we're going to watch a lot of this. So it was interesting. But in capital or death penalty cases, trials are often broken down into 3 distinct phases. It's guilt, aggravating, and penalty. The penalty is the sentencing. So the guilt phase essentially is to determine whether or not the defendant is guilty or not guilty. This is the main trial. This is what people are most familiar with. The main trial is the guilt phase. And then at the end of that, the jury says whether or not Lori is guilty or not. Then the second phase is the aggravating phase, which we're talking about now. And the aggravating phase, which is the penalty. Sometimes it can be part of the penalty phase, but the aggravating phase's goal is to determine if there are aggravating factors that make this crime eligible for a harsher sentence typically, or they can prevent evidence like this crime was especially heinous or cruel. The victim maybe was particularly vulnerable. There was a deadly weapon used, whether or not the defendant has a history of violent crimes. And these factors must be proven beyond a reasonable doubt. And in some jurisdictions, in some areas, the phase is combined with the penalty phase, like in Arizona. So in Arizona, you have this, it can be with the sentencing phase, excuse me. But in Arizona, they combine it right after happens right after the guilt phase. So right after the trial concludes and the guilty verdict comes back, then you have the aggravating phase. But for some reason, however, Lori does not want there to be an aggravation phase. So this was true her last trial too. Here in Arizona, the same thing happened. There was the guilt phase. The jury found her guilty. And then after, we thought that we were going to hear from victims. And I had mentioned that last time. I was like, you know what? Right after she's found guilty, we're going to go straight into aggravating phase. And we're going to hear about her aggravating factors, like the use of a deadly weapon or all these things that she did that make it particularly heinous. And the victims will speak. And Jerry Vallow was prepared to speak during the aggravating phase. But what happened instead? Well, Lori surprised all of us by stipulating the aggravating phase. She accepted all of the aggravating factors and said, yes, I agree with them all. Let's go. Let's be done. And so Jerry Vallow, Charles's brother, did not have an opportunity to share any words. And I always speculated that she stipulated and said she agreed to all of those aggravating factors because she did not want to listen to a victim, which is Charles Vallow's brother, Jerry. Or Kay Woodcock could have also done it. I think she handed the baton to Jerry. And Susan Vallow, who was in the courtroom, could have also done it. But Jerry Vallow was going to do that on behalf of Charles's family. Didn't happen because she said, nope, we're good. And so I have to wonder, why doesn't she want this aggravating phase? Is it because she doesn't want to hear from victims? It's just one thought in my mind. But her argument for why she doesn't want an aggravating factor is really she's just wanting to go against the standard procedure in Arizona. But let's listen to a little of what she has to say before she completely loses it on Judge Boreski. Take a listen.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
So after this, after Judge Boreski stated that the aggravators that the state are alleging to in this case include the infliction or threatening infliction of serious physical injury, the use or threatened use of a weapon during the commission of the crime, the presence of an accomplice, that would be Alex Cox, and the offense that caused emotional, physical, or financial distress to the victim and the victim's family. The defendant was previously convicted of a felony also within 10 years immediately preceding the date of the offense. He said that if she's found guilty, these aggravators are pretty inherent in the charges themselves, besides the one about prior convictions. So he's not sure which aggravators that Lori finds insufficient. So this is kind of a long clip, but I'm going to play it for you because you can see the escalation of both Lori and the judge getting more and more frustrated with each other. Take a listen.
I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
All right. 13.5B talks about amending the charge or the indictment.
Mhm.
Okay. Your charge is conspiracy to commit first degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first degree murder to conspiracy to commit second degree murder, there'd probably need to be a new probable cause.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence. And if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for
Oh,
the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right? Because it's conspiracy to commit first degree murder. That's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators being a dangerous offense, and these specific
Can I finish
aggravators
what I
are
said, what I
different,
was saying?
right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So,
No dangerous instrument or deadly weapon was used.
so because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts.
you're not entitled to one.
Okay,
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
this is not an amendment of the indictment?
It's not. There's a difference
It's an
between,
extension of the indictment. It's not in the indictment.
it's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
That's
aggravators,
exactly my point. After the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can
How
not.
are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend. What else?
Did you hear her get silent when she said finally, well, if you don't want to attend, you don't have to attend. And she essentially calmed down at that moment. Makes me think she's going to ask not to attend. She just wasn't getting it. Or Maybe I can say she doesn't want to get it. I felt like I got a great lesson in there. I was like, okay, like the judge is really explaining things to me. I get it. She didn't want to get it. You know, in other words, it's Arizona law that whether or not this is a death penalty case, the aggravating factor phase happens. Thanks to Blakely, it's case law moving forward. She just wasn't okay with that until, though, of course, Judge Borowski said, well, if you don't want to go, you don't have to go. And it was like silence. We'll see if she ends up going to the aggravating phase, which will happen right after the guilt phase or the hopefully guilty verdict. So I have to say I pinned this comment by MH. Can we please get "Are You Done" merch? Because this moment with the judge certainly reminded me of all of your requests. You guys have been requesting this now for a very long time, ever since Judge Borowski, asked Lori, "Are you done? Are you done?" Because I think it resonated with a lot of us. It's how a lot of us feel. We're on our third trial. Are you done yet, Lori? Are you done? So never fear. We have "Are You Done" merch. We have a lot of options too, guys. We have several designs. Are you done yet? Are you done yet? We even have tank tops because you guys requested. Oh, these are so good. Are you done yet? They're actually, we have a link to them below in this. If you're watching YouTube right now live, we have a link to our merchandise. If you're listening to this podcast episode on our podcast, we will have a link to all of our merchandise in the description of this episode. But not just that, I have to share something else that I love. And a lot of you are using the fly swatter emoji. Something else reminded me of that today. Aunt Vicky. Many of you know Aunt Vicky. She is Tammy Daybell's real life aunt, and we've adopted her as our Aunt Vicky. Well, she said that she wanted a fly swapper for every time Lori says, okay, which I've started to learn is sort of Lori's MO for when she's really, really upset, probably raging, and she's trying to control herself, because she'll go from just rage to like putting the mask back on, just going, okay. And Vicky said that she wanted a fly swatter for when she said that, to say, no, it's not okay. But look at this. These are at the Bloom and Bramble store in Orem, Utah. The Bloom and Bramble store is Aunt Vicky's store. So I just had to show that as well. So I love that. I love that. That's so great. Because after that, I thought we needed a fly swatter. So there you go. There you go. The second motion that Lori argued after that moment was about her headsets. The headsets are used during sidebar so that everyone can just stay at their tables, because Lori is representing herself and she's a convicted criminal. They don't really want her walking all over the courtroom and going up to the bench, which is oftentimes where sidebars can happen. So this time everyone stays at their tables and they have headphones. They only have 5 total for the room. So Lori gets 2 of them. The prosecution gets 1, and the judge gets 1, and the court reporter gets 1. And well, Lori isn't happy, because that means she has to choose just one person to have alongside her. I actually think it's nice that she has 2 of them. And but the judge quickly reminded her that she chose to represent herself. Thus, she really is the only one that needs them. Take a listen to this clip.
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue, that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that you did check into, and there's no more available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing because you are acting as your own attorney. You're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then it's an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time.
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay.
Okay. According to Aunt Vicky, no, it's not okay. The last concern Lori had was about making sure the door would not be opened to her other convictions. Take a listen.
I have one more issue.
Go ahead.
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay.
Tomorrow morning, they plan to start at 10 a.m. They will be going through some motions, and then they will have approximately 20 to 40 walk-in jurors, so in-person jurors. Today wasn't in person, tomorrow will be, that they will need to screen before they begin voir dire with the jurors. So let's go through all of the final juror numbers and everything that happened today. I said that I would save that for you guys till the very end. It was interesting. We took excellent notes. So I turned, by the way, to my producer, Grayson, who many of you are starting to get to know, after I said we took excellent notes, because she helped with that process. So let's go through them all. We start with A2. A2, starting a new job June 9th, but could participate. A3, no issues. A4 has some knowledge about the case and this case in particular. A5, a non-refundable paid vacation on the date range and biased about police. A6 had a procedure yesterday, questionable at how they'll do on recovery and getting to court. A7, childcare issues and knowledge on the defendant. A8, difficulty with English, mental health conditions, and not in Maricopa County. A9, would miss a lot of shifts at a new job. A10, no issues. A11, has something like a Comic Con at the convention center on Thursday and Monday. A12, no issues. A13, difficulty with English, didn't complete the rest of the questionnaire. A14, out of state until October, has heard some info regarding the defendant. All right. A15, 16, 17, no issues. 3 in a row. First time. Boom. A18, some knowledge of the defendant. A19, some challenges with hearing if there is muffled speaking. Has watched multiple TV shows on Lori. A20, has seen media and social media information. A21, no issues. Boom. A22, prior knowledge and somewhat of a hardship. A23, prior knowledge about the case, has some news exposure. State would agree for cause, defense agrees for bias. A24, out of town Monday and Tuesday. A25, work hardship if more than 3 days. A26, some exposure, although not much. A predisposition regarding police testimony. A27, no issues. A28, would need court to supply an Uber, has some prior knowledge. A29, watched a TV show and has prior knowledge of Lauren Daybell. A30, prior knowledge about the defendant. A31, unavailable for the second week of trial. A32, think they recall seeing this story on the local news. A33, no issues. A34, physical issues, taking prescription drugs and has prior knowledge. A35, no issues. A36, some prior knowledge. A37, pre-existing bias regarding police testimony. A38, childcare issues, kids on summer break, out of town July 5th through 8th. A39, no issues. A40, leaving town June 22nd, would like to think the police are always truthful, hence bias towards police. A41, long haul truck driver, would miss a lot of work. A42, hardship starting June 23rd, but has prior knowledge. A43, defense attorney who has an out-of-state case on June 9th, has some prior knowledge and has reported on the defendant as a legal correspondent on the local news. Probably a problem. A44, if it's a fairly short trial, they have no issues. But if extended, it would be difficult because they have 8 kids at home. Yeah, pretty difficult. Although they might need a break. Probably serving as a juror would feel pretty good. But 8 kids at home. A45, reports a traumatic brain injury in 2023 as well as a brain injury. Judge actually wanted to keep this juror on, but the state wanted to strike. The defense agrees with the state. So judge overruled there. A46, prior knowledge. There is no A47. A48, no issues. A49, financial hardship and knowledge about the defendant. A50, work issue and had heard about the defendant. A51, physical condition that could affect their ability. Predisposition on police testimony. A52, out of town on a business trip next week, expresses a definite bias in caps against the defendant. A53, work issues, has prior knowledge. A54, no issues. A55, out of the country the second week of trial and has prior knowledge. A56, has a college issue and has prior knowledge. A57, no issues. A58, prior knowledge about the defendant, some exposure through social media. A59, juror compensation fund would not pay them enough, has knowledge about the defendant. A60, no issues. A61, watched some of the last trial. Yeah, not going to work. A62, work issue, has prior knowledge. A63, would miss part of the second week, has prior knowledge. A64, has some prior knowledge. A65, no issues. A66, physical issue depending on how many breaks during trial. Court may be able to accommodate. A67, very thorough on financial hardship. A68 has prior knowledge, has to go to work after court for the Diamondbacks. A69 has prior knowledge. A70, prior knowledge, childcare issue. A71, no issues. A72 has prior knowledge. A73, no issues. A74, detention officer who has transported her before. This was great. A detention officer who has transported Lori before and has read news about the case. Yeah, not going to work. A75, out of state trip, second week of trial. A76, physical issue and prior knowledge. A77, physical issues, travel issues, and knows about the defendant. A78, no issues. Always a good one. A79, definite bias and opinion about the defendant. Probably not a good opinion either. Yeah. Nope, they didn't make it through. A80, prior knowledge about the defendant. A81, physical condition. A82, no issues. A83, prior knowledge about the case and work hardship. A84, may know one of the witnesses. Predisposition regarding police testimony. A85, difficulty with English. A86, out of town next week and also has prior knowledge. A87, work hardship but also has knowledge. A88, childcare issues and prior knowledge. A89, physical issues, doctor's appointments tomorrow, transportation issues. A90, elderly and does not feel comfortable driving long distances. A91, work issues and has heard Lori's name before. A92, work, financial hardship, jury fund, would not pay enough. A93, out of town on the 23rd. A94, unemployed and looking for a job. A95, no issues, but they will need to follow up and see if they have a bias against police. According to the court, they need to check on this. State says there are definite issues because he has a massive bias and says he was wrongfully convicted. So, problem. A96, they are deaf. A97, no issues. A98, prior knowledge, as well as A99, prior knowledge. A100, he has to take care of, or he or she has to take care of their parents. A101, out of town working the second week, but also has prior knowledge. A102, a predisposition or bias regarding police. State agrees for cause. Lori, at this one, this was great, says, I see no issue to keep them. Wants to question them further in person. The judge says they don't trust the police in general. So that's a problem. And I love it. Lori's like, this person's great. They don't trust the police. The judge is like, yeah, no. A103, out of the country starting June 4th. Lori says they need a minute now because they're having technical difficulties during this time. And I'm going to take a minute to call this intermission. A few things that was happening. I want to let you know. Brandon Boudreaux, the victim in this trial, which I don't even think we've talked about him yet today, but he is the victim. He is the reason we're all here and reporting. We want justice for Brandon Boudreaux because he was almost killed back in 2019 when Alex Cox, Lori's accomplice, allegedly shot at him while he was driving home. Brandon Boudreaux was virtual during this, and at one moment, he popped up on screen. I think it was an accident because it was just his name. You could see on screen that there were people watching, and he was one of them, Brandon Boudreaux. And for a moment, he popped up on screen, and I saw him, and I just want to say it was this moment of realizing like how lucky he was to be alive, but also like we haven't had a victim, a surviving victim yet, be able to testify and be able to be at a jury selection hearing. We've had survivors, family members, but the actual victim that was targeted. And it was interesting to see him. And then at one moment, I noticed his wife, Jenny Boudreaux, popped up on the screen. She was also listening from a separate place. And this is his new wife. He divorced Lori's niece shortly after this incident and had found love again and is married. So they were there today during this. Another thing I want to point out too, and we'll keep going, is that Lori always disagreed because of bias. So if she had an issue with a juror, she would say dismiss because of bias. The state would sometimes say that, but the state would also say that they were dismissing because of hardship or all of these other things you're hearing, right? You're hearing a lot of reasons why jurors can't serve, from being deaf to taking care of elderly parents to some other things we're going to hear, some really difficult hardships. Lori never dismisses because of hardships. And at one point I thought to myself, like, somebody's house could have burned down, they could be homeless and have terminal cancer, and Lori would still say like, oh, they're good, or dismiss because of bias. She would never dismiss someone because of a hardship. And it was just sort of, I want to point out this other really interesting aspect about jury selection with her. There's only one reason Lori dismisses a juror, and or says that she doesn't want to have that juror, and it's because of bias. And like I said, like, you know, they could have suffered the most horrendous tragedies in the world and she wouldn't dismiss them because of hardship, unlike the state. So intermission over. We are on A104. A104, no issues. A105, going to be in Idaho for a family reunion and has prior knowledge. Probably if they're going to a family reunion in Idaho, prior knowledge. A106 has prior knowledge about both cases. A107, no issue. A108, no issue. A109, prior knowledge about the defendant. A110, prior knowledge about the defendant. A111, being charged with a misdemeanor and DUI. No to question 5, which was either they were not 18 or they were not a citizen or not a resident of Maricopa County. So they can't serve as juror. A112, 112, physical issues, but no prior knowledge. A113, work and has prior knowledge. A114, prior knowledge. A115, issue with a child on June 4th, having a procedure and does have knowledge. There was no A116. A117, prior knowledge from the news. A118 has prior knowledge. A119, no issues. A120, in the state of Washington for the entire summer. A121, transportation issues with doctor's appointments, but also has prior knowledge. A122, difficulty with English. A123, no issues. 124, 125, no issues. A126, no issues as well. That was a good long grouping. No issues. A127, work hardship for summer job at school. A128, no issues. A129, prior knowledge about the defendant. A130 has a physical condition and also has difficulty with English. A131, childcare issues with grandchildren, also has prior knowledge. A132, no issues. A133, no issues, but needs a follow-up to question 21. A134, prior knowledge about the defendant and this particular case. A135, out of town the entire month of June and has prior knowledge about the case. I also just want to point out that a lot of people that live in Arizona, when it's 115 degrees out, it's hit even hotter, they do leave town. It's sort of like other place where it's really cold during the winter. A lot of people leave town in Arizona for the summer if they're able to. So A136, prior knowledge, but also has work issues. A137, prior knowledge about the case, is a nanny and cannot find replacement care. A138 and 139, no issues. A140 has prior knowledge about the defendant. A141, prior knowledge. A142, out of country for work next week, has prior knowledge. 143 has prior knowledge. 144, prior knowledge. 145 and 146 both have prior knowledge, and 146 also has a work hardship. A147, prior knowledge, as well as summer childcare issues. 148, prior knowledge. A149, in question 17, expresses political view about training police and putting more into social work. The state would move to strike, but they are willing to do a follow-up. Lori wants to do a follow-up, of course. Yes. A150 has a work hardship, but also has a bias that they would believe a police officer over another witness since they are a police officer themselves. A151, hearing issue that can be addressed. 152, prior knowledge about the defendant. 153, prior knowledge about the defendant. 154, takes care of a disabled brother in the morning until parents get home between 2 and 4 p.m. A155, out of state on June 23rd, does seem to recall allegations about the defendant. 156, no issues. 157, difficulty with English. 158, no issues. 159, financial hardships. And they're more likely to believe police. If they believe someone's accused, they're probably guilty. A160, health issues, prior knowledge. A161, caregiver for mother. A162, no issues. 163, mental health and childcare. 164, prior knowledge about the defendant. 165, work hardship, prior knowledge about the defendant. A166, no issues. 167, takes opioids for pain management. A168, very sad, stage 4 cancer. A 169, physical issues with walking, prior knowledge about the defendant from the news. A 170, expresses financial hardship and childcare. A 171, may have heard about the defendant, name is familiar. A 171, no issues. A 173, a vacation scheduled. A 174, bias about police officer testimony. And then again, there's a discussion of whether or not they're even being told the full truth. No 175. A 176, prior knowledge about the defendant, followed the last trial, watched news reports, and they're out of state June 6. 177, 178, no issues. 179, some issues that could affect things, out of town the next week, and they have some prior knowledge. A 180, they have a procedure scheduled for the 5th and prior knowledge. A 181, no issue. 182, needs 2 to 3 weeks notice to take off work, also has a learning disability. 183, prior knowledge. 184, out of town in Houston, working. 185, prior knowledge. 186, no issues, according to the judge. Trina says that he stopped filling out answers and did not affirm that they were true. So Trina has issues, judge doesn't. Further questioning. 187, problems with their eyes and prior knowledge. 188, no issues. 189, difficulty with English. 190, leaving Arizona for the summer on June 2nd. Prior knowledge. 191, father in hospice. Prior knowledge. 192, child care issues. 193, prior knowledge, and the husband has a medical issue. 194, difficulty with English. 195, out of town. 196, doctor's appointment tomorrow as well as June 18th. 197 and 198, no issues. 199, hearing issues. They're from Gilbert, though, and they think they've seen stuff about her. 200, more likely to believe police officers just because. 201, prior knowledge about the defendant. 202, work hardship. 203, no issue. 204, family vacation, prior knowledge about the defendant. 205, no issues. 206, prior knowledge. 207, prior knowledge. 208, physical issues, prior knowledge. 209, English difficulties. 210, no vehicle, lives over 30 miles away. 211, may need to follow up for question 17. 212, they live in Oklahoma. Somehow they got a jury questionnaire. 213, no issues. 214, prior knowledge. 215, prior knowledge, physical issues. 216, no issues. 217, prior knowledge. And they watched the last pretrial conference. 218, no issues. 219, physical issue. And if it went until the 23rd, they would not be available. Prior knowledge about the defendant. 220, prior knowledge about the defendant, doing work until June 11th. 221, no issues. 222, leaving June 5th out of state. 223, self-employed. Could miss a few days, but this schedule would be a lot for them. 224 and 225, no issues. 226, this is financial and a work hardship, prior knowledge. 227, prior knowledge. 228, out of state plane tickets, June 6th through 14th. 229, out of country, June 20th through 25th, prior knowledge. 230, prior knowledge, and quote, has a lot of stuff and feels like this was good. So 230, prior knowledge about the defendant, but this was a great quote from Judge Boreski. He says, they have a lot of stuff and it feels like she's yelling at us in all caps, end quote. So Judge Boreski didn't like the all caps yelling. I think he wanted to say, are you done yet? 231, mental health issues and transportation issues. 232, childcare issues. No. 233. 234, primary caretaker for a 95-year-old parent. 235, prior knowledge. 236, prior knowledge. 237, no issues. 238, vacation plan. 239, may have an anxiety attack if they're in an unfamiliar setting, and it would be also an educational hardship. 240, childcare issues, mental health issues. 241, no issues. 242, 243, and 244 both have work hardship and prior knowledge. 245 and health issues. 246, financial hardship. 247, out of state for a procedure June 4th through 8th. 248, one car for the entire family. His wife is going through chemo. 249, difficulty with English. 250, no issues. 251, they cannot afford to take that much time off of work. Grandfather was a DPS, and if he said you did it, then you did it. Yeah, next. 252, difficulty with English. 253, work hardship, physical hardship, and prior knowledge. 254, they're moving and prior knowledge. 255, answer. 217 doesn't make sense. They're concerned about that. 256, medication issues and prior knowledge. 257, out of town the first week of June, prior knowledge. 258, this was an interesting one. So the judge paused at 258 and said, who knows what a donut operator is? And we were all like, well, that's odd. Probably somebody that makes donuts, but they said that they have a bias in favor of police from watching Donut Operator on YouTube. Anybody know? 259, take your pick on the answers. No 260. 261, physical issues with vision. 262, work issues, prior knowledge about the defendant. 263, memory loss. 264, work hardship, prior knowledge about the defendant. 265, prior knowledge. 266, prior knowledge. 267, prior knowledge. 268, English difficulty. 269, traveling. 270, physical issues and a bias against police. 271, felon. 272, primary caregiver. 273, primary knowledge about the defendant and medical issues. 274, would miss June 23rd. 275, no issue. 276, out of state and previous knowledge. 277, physical issues. 278, a follow-up about a DUI is needed. They'll figure that out. 279, hearing issues, but they can get an amplifier. 280, no issues. 281, prior knowledge. 282, no issues. 283, prior knowledge. 284, financial work issues, prior knowledge. 285, surgery Friday the 13th. Not a day I want to get surgery, but nonetheless, surgery on Friday the 13th. Prior knowledge about the defendant. 286, non-refundable airline ticket during the trial. 287, prior knowledge. 288, moderate hearing loss and primary caregiver for a 5-year-old. 289, difficulty with English. 290, prior knowledge about the defendant. 291, more likely to believe a police officer, but they would go by the facts. They're just being honest. I like that one. 292, no issues. 293, difficulty with English. 294, no issues. 295, question 21. It's a completely 221, it's a completely unformed system. Psychopath. They said something about a psychopath. I just looked at Grayson. Whoa, remind me of this one. It was weird. Yeah, whether they called her a psychopath or said they were a psychopath, we don't know. But they won't be a juror. 296, difficulty with English. 297, difficulty with English. 298, physical and mental condition, bias against justice system in general. 299, cruise in Europe, second week of trial. Jealous. 300, no issues. 301, financial hardship. 302, work hardship, some knowledge about the defendant. So, some interesting stuff, right? Wow. I wasn't able to see who was here with me sticking around for this while I read those. So I'm back and I see that there are over 6,000 people here still in chat with us. I love it. I love how invested we are all in this trial, including jury selection and understanding this process. So to recap, total moving forward of jurors are 66. That's what we know so far. And the total who know about the case, 126 jurors knew about the case. And then there will be 20 to 40 jurors who are walk-ins tomorrow that we will additionally learn about. The judge explained that sometimes there are just certain potential jurors who don't fill out the sheet, but they still appear for jury duty. That's me, by the way. When he said that, at first I was like, what? And then I was like, wait, that's what I do. Like, Who has time to fill out a sheet? But I will show up for my jury duty. That's what I put on the calendar. So he said, those people that didn't fill out the questionnaire and send it back in, they're going to show up tomorrow. So we have 20 to 40 walk-ins tomorrow, and in 66 moving forward. And what was the percentage again? All right. Okay. I wasn't sure. So 42, we figured this out. It's really interesting. 42%, 42.65% had last time, had previous knowledge of Lori. So this time, number crunching, it was 42.85%. Isn't that wild? Like, if you want to know if people are telling the truth, like, I feel like you just did a little bit of a research project there with those numbers. That potential jurors, about 42% of them have previous knowledge of Lori Vallow Daybell. I wonder if she knew that, she'd be mad. If she's like, why don't you all know about me? I think that she doesn't believe them when they say that they have no knowledge of her. It was an interesting first day. I mean, let's just like go through the whole day one more time. I wake up this morning thinking that I could just be like lazy and go on a run because we don't have to be in court until 1 p.m. So I'm like, this is going to be about the only morning I have next, few weeks. We wake up to multiple motions that hit the docket, which we covered in our earlier episode this morning. And then we go to court, and all of us realize that we missed this super secret hearing where she rips on Judge Boreski, and another judge puts her in her place and is like, yeah, he's going to stay your judge. Sit down. Then we go to jury selection, took all those fancy notes. Thank you, Grayson. It was very interesting. Brandon's there. We think that's good. And then Lori's like, wait a minute, hold my Kleenex, because she was holding a really ratty Kleenex the whole time. I mean, she's emotional. So you guys saw that. Pool camera guy even got a close-up of that dirty Kleenex she held the whole time with her handcuffed hands and her shackles. And Lori's like, hold my water. Wait a minute. I've got some things to say. I think I was actually talking to a fellow journalist, Mike Watkins, today. He's a legend. He was there. Only 11 people in the gallery today listening to jury selection, and he was one of them. And we were chatting. Many of you might know him from his work he was a big reporter during Warren Jeffs. So I said, I think what's going to happen, I think she's mad. I said, I think Lori's acting up because she was being on her best behavior for the first Arizona trial as she was representing herself over Lori Vallow. And the best behavior isn't great. Like, look, we saw some bad behavior from Lori, but her best behavior, I mean, she has her limits, right? Lori Daybell. She's limited, and she was probably on her best behavior that first trial. And we are honestly seeing her sort of acting up and getting angry, wanting to recuse the judge, interrupt the judge, argue these things over and over and over again. And I honestly think that it's because she is angry. I think that she thought she was going to win that first trial. And by win, I mean that she thought that the verdict was going to come back that she was innocent. And when it didn't, she's angry, and it's showing. And I that's what I think. Of course, I'm not a psychologist. I'm only married to one. So I'm the journalist. He's a psychologist. Sometimes I pretend to be one. Not really. I'll never pretend to be one, but I like to speculate with all of you. So I am going to ask Dr. John his thoughts. He is watching everything, and we will have that actually on patreon.com/hidden true crime, as well as for our Apple subscribers. We'll bring that. And Dr. John, my husband, the criminal psychologist in our little group here, he will also be coming on YouTube as well throughout this trial to give his take, because I think we're going to see a Lori like we've never seen before. Well, I shouldn't say that. take that back. We're going to see Lori in her most classic Lori form. We've seen a lot of Lori. So we've seen this Lori before, but she's going to show the whole world this Lori is my prediction. I don't know. Maybe she'll behave. I don't know. So let's go over to some starred comments. Oh, first off, thank you. Thank you so much, CK. I appreciate it. To buy me a drink, I might need it. What makes you think that? I don't know what you're talking about. Just kidding. Thank you very much. Jen, yes, 6,000 plus watching a reputable media agency talking about a non-reputable attorney. Thank you, Sassy Pants, about my nails. That's because my producer, Grayson, told me that I needed nicer nails. So she took me and she told them what to do. And now I'm frustrated because I can't text or type well, but they look pretty. So thank you. Thank you everyone for the new memberships. We're so glad. Troublemaker Baker, our moderator, is creating new emojis for this trial, and we will be live streaming this trial every day. And we are so grateful for everyone that gifts memberships as well. We want everyone to be a member during this trial. We love our live streams, our daily live streams. Wordwise. Wordwise. Wordwise says, I think you're 100% right, Lauren. Lori is decompensating because she lost her last trial and can't reconcile that fact with her belief that she's a better lawyer than everyone else. Exactly. And validation from Wordwise is extra validation, because if you guys haven't checked out Wordwise's channel, go check it out. She reads Chad Daybell's books, Melanie Gibbs' books. She reads books by criminals so that we don't have to. And she does an incredible job breaking them down and critiquing the books. And you learn a lot. So go give Wordwise a subscribe as well. She is somebody we need in this community. She does great work. And then Tara asks, question, is the 30-minute delay still in place for this trial? It is. Court TV requested a little bit more leeway. The judge has denied it. So the live stream, I guess I shouldn't technically call it a live stream because there is going to be a 30-minute delay. So we will start the live stream at the time court starts, explaining that you're on the right stream. Just there's a standby. We're waiting for the 30-minute delay, and then court will begin. Now, I will be in court in the courtroom as future Lauren. I won't give too many spoilers away, but future Lauren can give all of you heads up when something is going to happen. So, Debbie, thank you so much. And Mary is asking, where is Dr. John? Dr. John is making it possible for me to be here attending trial. He is full-time parenting at home and holding down the fort, literally and figuratively. So I'm so grateful for him to make this possible. And Diet Coke Addict bought her new shirt off the merch section. I love it. Are we done yet? It is the question we are all asking ourselves. Are we done yet, Lori? I think that we all can relate to Judge Boreski's words. Are you done yet? So that link the link to our merchandise is pinned in the chat. It will be pinned in comments and in the description of this episode. To all the moderators, thank you so much. We couldn't do these live chats every day without you. And again, our moderators, you guys don't know when we're going live. Well, guess what? Our moderators don't know when I'm going live. I jump on and I'm just lucky. So many of them show up day in and day out. They are incredible and they do so much for our channel. So thank you. Thank you. Thank you. All right, everyone. We'll see you tomorrow. I know it's just jury selection, but you never know what each day is going to bring. And I have a feeling, as I've said, this is going to be a very long journey we're taking together. So buckle up. May justice be served.